Hello, welcome to Levin Salomon's series of videos on antitrust law. We want to share with you some of the experience and insights that we have gained over 20 years of practice in this area of law, which is both very important and also tremendously interesting. We will discuss with you over 6 videos in Portuguese and English the questions that are most often asked by clients in our daily practice. I'll give 3 examples. What type of transactions must be cleared before Brazilian Antitrust Tribunal CADE? Or does this particular type of conduct amount to an infringement of antitrust law? Or still, under which circumstances does it make sense to reach out to CADE to discuss leniency? This first video will discuss merger control. In Brazil, as in many jurisdictions throughout the world, transactions that meet certain legal requirements must obtain clearance before the antitrust tribunal in order to be closed. Failure to file these transactions before CADE may lead to a fine for gun jumping, which may amount to up to 60 million reais, and may also lead to the very annulment of the transaction. Now, the transactions that must be filed before CADE are those that meet the so-called 3-prong test. The first part of the test has to do with the nature of the transaction. Transactions that must be filed are those that Brazilian law defines as concentration acts. These are essentially mergers between companies, the acquisition of an equity stake in another company, absorbing another company, or still some types of agreements such as joint ventures or association agreements which result in a company acquiring decision-making power in the business of the second company. The second test has to do with the turnover of the parties involved in the transaction at hand. At least one of the parties must have a turnover in the preceding year in Brazil of at least 750 million reais, and at least another party to the transaction must have a turnover of at least 75 million reais in Brazil, also in the preceding year. Finally, the third part of the 3-prong test has to do with the effects of the transaction. If it is performed in part or totally in Brazil, or if it has the potential to produce effects in Brazil, then it is considered that this effects test is met.
There is no clear statutory rule regarding when the effects test is met, but CADE has been consistently considering 3 aspects. The first one is whether the target company is expected to generate revenues in Brazil in the near future, let's say up to 5 years. The second one is whether the parties have horizontal or vertical relationships that could affect Brazil. And the last one is whether the geographic scope of the market is global or regional, and this region encompasses Brazil, like, let's say, Latin America. Other peculiarities also warrant a specific assessment. When investment funds are involved in the transaction, specific rules apply to the definition of economic groups. Belong to the same economic group of the investment fund quota holders with 50% or more of the quotas, and also portfolio companies which in the fund has 20% or more of the quotas. Finally, certain types of agreements between competitors might also be subject to mandatory filing, especially if they involve the sharing of costs and revenues, and the duration of the agreement is of 2 years or more.